Okay, let's go ahead and get started. Good evening and welcome. On behalf of the University of New Mexico School of Law, thank you for joining us for the U.S. Senator Dennis Chavez Endowed Lecture on Law and Civil Rights. We are truly pleased to see so many members of our law school, the university, and the legal community here this evening. We are especially grateful to the Chavez and Tristani families, whose generosity and partnership have made this lectureship possible. Their support reflects a deep commitment to sustaining meaningful conversations about law, civil rights, and the values that shape our public life. At this time, I would like to ask the members of the Chavez and Tristani families to please stand to be recognized. This lecture series exists to create space for thoughtful dialogue that challenges us, informs us, and connects legal scholarship with lived experience. It brings together students, faculty, practitioners, and community members to engage with issues that remain as urgent today as ever. Tonight's gathering is not only about learning, but also about connection across generations, across disciplines, and across perspectives. It is an opportunity to reflect on the role of law in advancing equity, justice, and human dignity, and to consider how each of us contributes to that work. Before we begin this evening's lecture, I am pleased to invite Charles Coy, the great-grandson of Senator Chavez, to offer a few words on Senator Chavez's life and legacy. Please join me in welcoming Charles Coy.
Good evening. What I really want to do is welcome everyone from Senator Chavez's family, on behalf of Senator Chavez's family. My name is Charles Coy. I am the great-grandson of Senator Dennis Chavez. So on behalf of our entire extended family that's here tonight, we wanted to welcome you to tonight's lecture. We have several members of the Senator's families you just saw here with us tonight. We have two grandchildren of the Senator. First, I'd like to point out Gloria Tristani, who is here. She was gracious enough, or perhaps persistent enough, to encourage me to attend the event, and I'm grateful that she did. I'm glad to be here. She works hard to help bring meaningful programming to this endowment, and so thank you, Keka. Also tonight with us is another grandchild of the Senator, Jorge Tristani. Where'd he go? Oh, there he is. Although he's better known around these parts as Coach Tristani. For decades, Jorge has played a vital role in preserving a remarkable trove of exhibits, correspondence, letters, memorabilia from the Senator's life. So thank you, Jorge. And in accordance with an adage that Jorge's always travel in pairs, we're also joined tonight by my cousin Jorge Thompson, another of Senator Chavez's great-grandsons. Jorge shared a glamorous Southwest flight from Burbank with me and my son Maxwell Coy just this morning. Max, who's with us, is a great-great-grandson of El Senador, and while he's honored to be here for the lecture, I suspect he's also motivated by his first proper green chili fix in years. And on a more personal note, I want to also welcome you tonight on behalf of those who couldn't be here, particularly my late mother, Sissy Coy, who always loved these lectures. As a writer and journalist, my mother spent decades immersed in her grandfather's life. She called him Poppy, eventually publishing a biography of him for young readers, hoping to bring his story and legacy to new generations. For Sissy, Dennis Chavez was never simply history. He was memory, a voice, a presence, her beloved grandfather. She came of age in a world he had helped shape, surrounded by people for whom his battles against discrimination, his insistence on widening opportunity for every American, and his refusal to flinch in the face of powerful opposition, these things were not biography, but lived experience. Her generation carried Poppy with them the way you carry someone you love, and most of them now are gone. My son Max, however, seated here tonight, represents something different and something equally important. He is 18, about to begin college, and considering a future in public service. He never met his great-great-grandfather. He has no memory of him, no stories from the dinner table. What Max has instead are the ideals themselves, distilled, tested by time, and still standing. In a recent school essay, Max wrote, "I come from vastly different circumstances than El Senador did. I have had opportunities he could have never imagined. I know that these are opportunities he fought so hard to make possible, and I'm determined not to waste them. While I may never have my own statue in the U.S. Capitol, I want to work hard to make sure that his statue and the virtues he championed throughout his life remain intact." What strikes me in, thank you. What strikes me in reading Max's words is that the world young people are stepping into today, an era of democratic norms tested in ways many of us never expected to see, is in its own way not so different from the world Dennis Chavez navigated. The fault lines may have shifted since the senator's time, but the need for principled leadership and the refusal to choose comfort over conviction has only grown more urgent. So I think this is the thread that connects my mother's generation to my son's, across a world that would be almost unrecognizable to the man who inspired them both. It's not memory, it's not proximity, but the enduring force of ideals that were tested in the senator's lifetime and are being tested again in ours. So I say welcome from the family of Senator Dennis Chavez, from all of us, and especially our youngest generation stepping now into their own future. We're grateful you're here. Thank you.
I want to thank you. It's a great turnout. My name is Martin Chavez, and you're probably wondering what I'm doing here. So I'll tell you real briefly. One, I attended Georgetown University, but as you know, the senator was a graduate of Georgetown University Law Center. And in those days, UNM law didn't really exist. And he set about to encourage and foster and mentor countless young New Mexicans, help them get into law school, help them get jobs in Washington. My late father, Lorenzo Chavez, is one such very fortunate New Mexican who the senator took under his wing and brought him in. Goodness gracious, at one point, my father chaired the commission to create the statue of Senator Chavez in Statuary Hall. We had wonderful pictures of Gloria, she's my next door neighbor as well, at that commemoration. But in fact, my father wouldn't have had his successes in his life without the senator. I wouldn't have had my successes without the senator. And frankly, just about everybody here in New Mexico, in this room and in the state, can find a way that they benefited from the senator's tremendous legacy. We also handled my father and I handled the transfer of papers from the University of Albuquerque to UNM, where they're here now for all the students and all New Mexicans. So that's why I'm here. Let's talk about why you're here. Professor Stephen Vladeck is incredibly accomplished at an extraordinarily and ridiculously young age. He is a professor of federal courts at Georgetown University Law Center. He's an expert in federal courts, national security, military justice. He couldn't get into Georgetown, so he had to go to Yale. It happens, where he had to be the editor of the Law Review there. And then he had to endure clerkships in both the 11th Circuit and 9th Circuit Federal Court of Appeals. Not bad for a Yale kid. He really is an accomplished fellow. You'll see him on CNN as a regular commentator, but he really is an expert in the federal courts, and that's what we're here for, to hear from the professor this evening, because if we ever had a time when we needed expertise on our federal courts, it's right now. So please welcome Professor Stephen Vladeck.
I always try to lower expectations before a talk, so I don't know about that introduction. Thank you for the introduction. Thank you to the Chavez and Tristani family. It is such an honor for me to give this year's lecture. It's a treat to be back in New Mexico. I've been here a few times before. They haven't kicked me out yet. They did kick me out of Texas, though, so I think that's probably a net positive. It says a lot about New Mexico that that's an applause line. But I wanted to spend some time this evening trying to tie Senator Chavez's legacy when it comes to law and civil rights to our current Supreme Court, which may not be the first thing you think about when you think about law and civil rights. And so my goal this evening is to tell a story and hopefully persuade you. Not that things are problematic with the Supreme Court. I suspect you already knew that. Not the New Mexico Supreme Court, the US Supreme Court. But that actually I think folks have the wrong sort of perspective, or we're not identifying the right problems with the Supreme Court, and therefore we're actually having, I think, the wrong conversation about how and why we should fix it. But I wanted to start with Senator Chavez, and what I think of as one of his more famous moments, his speech on the floor of the Senate in 1950 when he stood up to Senator Joseph McCarthy. And one of the things that I've always found striking about that speech is he referred to this country as a nation of dissenters. Which strikes me as such a powerful way of thinking about our tradition, not just of free speech, but of actually being critics, of not being shy, in his case, about being the first person to push back against something just because that was the popular vibe at the moment, of standing up for what you believe in, even when maybe when you stand up first, no one's standing next to you. And so it seems to me that part of that legacy is the importance of being unafraid to go first, the importance of leading when it comes to pushing for reforms, when it comes to calling out things that are wrong or that are unjust or that need to be fixed. But also, and I think this was implicit in so much of the senator's work, especially around civil rights, the role courts do play, have played, must play in vindicating this ideal. Because a nation of dissenters is a nation of minorities. It's a nation of individuals bucking the popular trend. It's a nation of standing up to tyrannies of the majority. And it's why we have courts in our system, especially our federal courts. And I think there are ways in which that has perhaps broken down in recent, Supreme Court cases. All right. So why do we need courts? The Supreme Court, as you might have heard, has become a bit of a lightning rod. Spoiler alert. The justices' behavior, both on and off the bench, has led to understandable calls for reform. We're seeing more conversation about Supreme Court reform right now than we've seen at any point, really since the 1930s. When the senator was with us, but none of us were here. And what's striking about that is that many of these reforms are pitched as, are intended to, and indeed would weaken the Supreme Court, that the perceptions that the court has too much power, and that we need to actually dilute, to minimize, to take away the power of the court, whether by adding a number of justices, whether by taking away its jurisdiction over certain cases. And my goal this evening is to persuade you that this would be myopic, and that what we actually need is a better court, not a weaker court. And that, in fact, events of the last 13 and a half months ought to persuade all of us that without courts, we might even be worse off than we are. So that's the goal. We'll see how it goes. There'll be a quiz on the way out, just for the students. Okay. So let me start with the Supreme Court we have before I spend a few minutes talking about the court we had, and then pivot to the court we need. So I like to start with this picture. You guys, I hope, have maybe seen this picture before. Maybe you recognize it. This is the official class photo of the US Supreme Court. And the reason why I like to start with it is because it's not real. And what I mean by that is this is not one picture. If you go to the Supreme Court's website, if you pull up the official photo of the Supreme Court, you find this, which is actually a digital composite. They take like a whole bunch of pictures, and then the justices each get to pick their favorite one of them, and then it gets morphed into one image. That is the least important thing I could tell you about the Supreme Court, except that I think it really illustrates, literally, how carefully the court sort of calibrates its public persona, how carefully it negotiates its relationship with the public, how much it is actually invested in putting out an image that in this case is literally not an image, just as a way of grounding our conversation. Here's another image. This is Gallup polling on whether people approve or disapprove of the Supreme Court. And it's not good. So if I don't expect you folks in the back to be able to read the fine print, but hopefully you will trust me when I say public approval of the Supreme Court is at what's basically an all-time low since Gallup started polling on this. Now, folks who defend the Supreme Court say, well, it's still higher than Congress. If that's what you're comparing yourself to. But this is a problem. It's a problem not just because it's a symptom of a broader disease, it's a problem because the Supreme Court's power is soft power. Right? The Supreme Court, it has a police force, but not one that goes out in the world and enforces its mandates. When the Supreme Court in 1974 ordered President Nixon to turn over the Watergate tapes, Warren Burger did not march up Pennsylvania Avenue with the mandate. Right? The court's power comes from us. The court's power comes from broad, diffuse public support for the court as an institution. The idea, not necessarily that we agree with the justices' principles, but that we at least agree that they are principled. Right? And that is what is at an all-time low, and that is a huge problem because it actually empowers attacks on the courts. It delegitimizes the court. Even if the court might, to a large degree, be responsible for why it has become so unpopular. This is another graphic that you've probably not seen before. This is the Supreme Court's docket over time. This is also my heart rate today when I was having trouble getting here. But all I want you to take away from this, if you look to the far right of the screen, you might notice that the Supreme Court's overall output, the cases in which it is hearing oral argument and writing those 170-page opinions, is actually at the lowest level it's been since 1864. That's a long time. And that is not a one-off. This has actually been a consistent trend since COVID, since the COVID term of October 2019. I suspect that if you were wondering what you were going to learn tonight, the notion that the Supreme Court is doing less was not high on the list. Because the court is at the same time not just doing less, but doing more of the ideologically divisive, politically charged, culture war, red meat type of cases that are directly responsible for its declining popularity. So just a couple of examples from what we might call the merits docket, the cases the court is hearing this term has already heard. We have the big Colorado case about the constitutionality of Colorado's ban on conversion therapy. We have the Louisiana redistricting dispute about whether it is unconstitutional for Congress to tell courts that you can remedy a violation of the Voting Rights Act by drawing racially conscious districts. Makes you wonder why we have the Voting Rights Act. Transgender discrimination in schools, the court has a couple of very big cases about that, especially in athletics. Campaign contribution limits, if you know anything about the Supreme Court and campaign contribution limits, you know how this case is coming out. Right? And the reality is, like, these cases, I am not especially good at making predictions, especially about the future. They're all going to be 6-3. And we know who the 6 are, and we know who the 3 are, and that's not a great thing for the court. As Justice White put it in 1986, these kinds of cases are those in which the court is most vulnerable and comes nearest to illegitimacy. The cases where the court is sticking its neck out in ways that are perceived, however rightly or wrongly, as ideological. So at the same time as the court is actually hearing fewer cases, a larger total number of its cases are these, not the super fun civil procedure cases that I love to teach to my 1Ls. And that means, I realize that this is a law lecture, there was not supposed to be math, but if the numerator is higher and the denominator is lower, it means that as a total percentage of the court's docket, this has become a dominant part of the Supreme Court's work, these kinds of cases. Then there's the shadow docket. So emergency applications, sort of the crash course when courts are trying to figure out what the status quo should be for the 6 months, 2 years, 4 years that a case is going to take to progress all the way to final judgment. Should they put the law back into effect if a lower court blocked it? Should they block a law that the lower courts refused to block? This is not new, but the Supreme Court has been doing a heck of a lot more of this lately than ever before, especially over the last 10 years, starting in 2016, and especially since last January 20th, when something happened. There's a reason for that date. It'll come to me later in the lecture. This is an example. This is the ruling in a case called McMahon versus New York. This was a case about the Trump administration basically cutting the Department of Education in half. A federal judge in Boston, Massachusetts said, no, you can't do that, and issued a preliminary injunction, wrote a lengthy opinion about why the plaintiffs had standing, why the court had jurisdiction, why they were likely to win on the merits. The Federal Appeals Court in Boston, the First Circuit, denied a request from the Trump administration to freeze that ruling, wrote an opinion, said, here's what's going on. Then the Trump administration went to the Supreme Court. This is all that the Supreme Court wrote, and even if you can't read it, I hope you'll trust me when I say it is boilerplate. There is no analysis. There is no explanation of why the lower courts were wrong. There is no explanation of why, for example, this case shouldn't have been allowed to go forward. This is happening all the time. It happened Monday night. I was actually really grateful for the justices for giving me fodder right before the lecture. I sent them a thank you note. Monday night, the court put back into effect the 11th House District in New York for Representative Nicole Malliotakis in a 107-word order that said nothing about why the state trial court had been wrong when it ordered the New York Redistricting Commission to redraw that district. These used to happen once in a blue moon. They are now happening all the time. Just a data point on that. During the Bush and Obama administrations, two, I think we can all agree, slightly different, two-term presidents, two-term presidencies, the federal government sought this kind of relief from the Supreme Court a total of 8 times, so once every other year. In his first 13 months in office, President Trump has sought it 33 times. Again, math is hard, but even that math is not that hard. So there are 5 different problems with this behavior, and I'm going to talk about them briefly. I'm happy to come back to some of this in the Q&A. Obviously, these rulings are producing massive effects, cutting the Department of Education in half, kicking every transgender service member out of the military, allowing President Trump to refuse to spend $4 billion in mandatory foreign aid funding. Keep going. Revoking temporary protected status for Venezuelan nationals, canceling President Biden's parole program for Cuban, Haitian, Nicaraguan, and Venezuelan nationals. There are 33 of them. So these are having huge effects. The court is not telling us why. For the lawyers in the room, don't raise your hands. We know who you are. Right? The sort of the doctrinal moves that the court is making, it's assuming that the government is always irreparably harmed, which is supposed to be the trigger for giving relief now as opposed to later, just because it's the government. That actually doesn't make much sense if you pull it apart, because sometimes the thing the president is doing that's illegal is violating an act of Congress. Who's irreparably harmed there? I would say Congress is. But what do I know? This is my favorite social media post over the weekend about Iran, by the way. It's a good thing Congress isn't alive to see this. It was not mine, but it was good. Shamelessly steal material, right? Law professors. But even more perniciously, I think what is perhaps the most vexing thing about all of these emergency rulings, and the ICE rates case from Los Angeles is a good example, is courts are supposed to balance the equities in these cases. Like, who is harmed more? The party that won below if I block the ruling, or the party that lost below if I don't intervene? And instead what the court is basically saying is, as long as the government's harmed, the equities are awash. So take the Los Angeles ICE raids case. In Los Angeles, a federal judge told ICE, you have to stop stopping people based solely on their national origin, their skin color, whether they speak English with a thick Spanish accent, and where they hang out and where they work. Those can be plus factors for stopping them, but by themselves, those are not evidence that you are unlawfully present in the United States. No kidding. I don't think I have to tell a room of people from New Mexico why that is. I think the scientific term is bollocks. So the district judge says you have to stop doing it. The Ninth Circuit denied a stay. The Supreme Court granted a stay. No opinion, but Justice Kavanaugh wrote a concurring opinion where he says, obviously the government is harmed if it can't enforce this policy because he says there are 2 million undocumented immigrants, that's not the term he used, living in and around Los Angeles who are subject to stop, arrest, and detention under this policy. He never mentioned that under that same policy, there were 10 million Angelenos who could have been stopped, arrested, and detained who were not lawfully subject to being arrested and detained on immigration charges. Again, math is hard. 10 million, 2 million. That doesn't sound like a wash to me, but that's what they're doing. One might defend, and there are folks who have defended the court's behavior, as, well, they're allowed to change the rules. And so maybe they've just decided that we're going to have new rules for emergency relief. So my first response is, it sure would be nice if they told us. We're supposed to guess. But in any event, they're not acting consistently. There are so many examples of cases where the court is not doing this if President Trump is not involved, where the court is sticking to the conventional rules for emergency relief. And then there's my favorite. My favorite is the court is treating unexplained orders with no analysis, as precedents, where lower courts are bound to follow them in other cases, and where Justice Gorsuch, in a concurring opinion last August in a case called NIH, actually chastised 3 different district judges for, in his words, defying the Supreme Court. Accusing judges of defying the Supreme Court is not something you see every day, and it usually actually depends upon, more than just you defied what we thought we intended when we didn't write anything. But that's where we are. That, in turn, has actually provoked a lot of pushback, a lot of sharp, hostile criticisms from lower federal court judges, who I think are rightly vexed by all of this. Okay, then there's my guy, Justice Alito. Love him. And not just because he's a Phillies fan. The one thing we bond on, by the way, is that we both root against the Nationals. It works that well. So in July 2023, Justice Alito gave this quote to the Wall Street Journal. And he said, I know this is a controversial view, but I'm willing to say it. No provision in the Constitution gives Congress the authority to regulate the Supreme Court, period. The period, by the way, is what makes this art. So he's literally wrong. This is Article 3, Section 2, Clause 2 of the Constitution, which, if you haven't, brushed out your hymnals lately, literally gives Congress the power to make regulations to the Supreme Court's appellate jurisdiction, to control the court's docket. But I actually want to suggest that he's on to something really important, which is that even though he's literally wrong, he's capturing what's in the zeitgeist. He's capturing the idea that Congress shouldn't regulate the court, largely because at this moment in American history, Congress doesn't regulate the Supreme Court. And so that, I think, is the real story that you can pick up from other pieces of evidence. Here is Chief Justice Roberts. There's no way you can read this, so I could tell you it says anything and you'd believe me. But here's Chief Justice Roberts in April of 2023 declining an invitation to testify before the Senate Judiciary Committee because Chief Justices don't do that. It would raise serious questions about judicial independence and the separation of powers. Never mind the rich history of Chief Justices testifying before Congress in support of legislation. Right? And he comes back to this theme in his year-end report in 2024. All of these pieces, what they all have in common is a court that is not looking over its shoulder. A court that can hand down massively impactful rulings and not worry about having to explain itself. A court that can say, of course Congress can't regulate us. A court that can have justices engaging in deeply questionable personal behavior off the bench. Is a court that is not worried about consequences. And I want to submit it is a court that is not accountable. And that the real problem with the current Supreme Court is not that we have a 6-3 Republican supermajority. We've had that before. It's not that there are people on the court who maybe you don't like. We have had that before. Boy, let me tell you about James McReynolds, who was a virulent anti-Semite who refused to be in the same room as Justice Brandeis. Details. But we survived all of that. Why? Because the court we had was much more accountable. And so let me sort of pivot a bit to the history. Congress, I know we don't, we history classes talk about Congress. Congress used to pull all kinds of levers when it came to the Supreme Court. Here are just a couple of examples. The number of justices, right? Congress varied the size of the Supreme Court from 6 justices in 1789. You might say 6 is a very odd number. Took you a second. I have 2 girls. I need dad jokes. Right, but Congress varied the size of the court for political, not always partisan, but political reasons. 7 times between 1789 and 1869. They haven't done it since, right? All of that was Congress using its power to control the size of the court as a way of nudging the court, as a way of shaping and altering the direction of the court. Where the court sits, you have probably not thought that much about this one. But from 1810 to 1935, the Supreme Court sat in the Capitol. Including until 1860 in the basement. All right, how many of you have lived in your parents' basements? Or how many of you have kids living in your basement right now? Who's independent in that story, right? This was not an accident. This was Congress keeping the court under its eye, right? This was Congress keeping the court close at hand. This was part of how Congress leveraged the court. Hey, we won't pick up your garbage. Etc. When the court sits, so you might know the court sits on the first Monday in October. That is a statute, right, that Congress most recently updated in 1917. If you've ever learned the facts of Marbury versus Madison at some point in your lives, sorry, right, Congress in fact used this power to keep the court from sitting at all in 1802 to prevent the court from ruling against the Jefferson administration. It was not an accident, right? Congress in April changed the court's annual term to February. Oh, whoops. We didn't realize that would keep you from sitting for 17 months. What a coincidence. Right? Again, levers, like, hey, we can destroy you if you get too far out of line. My favorite, the court's budget. You might know, at least vaguely, that the Constitution protects the justices' salaries from diminution, so Congress can't lower the justices' salaries. It's about $3 million these days. The court's budget is $160 million. So 98% of the court's budget is not constitutionally required appropriations. Congress used to use this as levers. Let me give you 2 examples. One, in 1964, when Congress finally gave the entire federal workforce a long overdue post-World War II deflationary raise. The 9 federal employees who got the lowest raise were the justices of the Supreme Court because Congress was mad at the court about a case called Reynolds versus Sims. Didn't violate Article 3, they got more money, but they got less more money, right, than everybody else. That was Congress being snarky. Then there's this statute. I'm going to paraphrase this one too. This is an 1882 statute, and it basically says, "Dear Justice Ward Hunt, we, Congress, want you to retire. If you retire in the next 30 days, we will give you a pension. Love, Congress." Guess what Justice Ward Hunt did? He retired. There was this whole brouhaha like last year or 2 years ago when John Oliver on Last Week Tonight offered Justice Thomas $1 million to retire. And I'm like, he's just following the Ward Hunt example that everybody knows. Congress did this all the time, right? This statute is not famous because it wasn't that unusual, right? Because things like this were the norm for how Congress related to the Supreme Court historically. The sort of last 2 ways Congress nudged the court. The first, the justices travel. If you're not a lawyer, you might not have heard much about circuit riding. So for the first really like 80 years of the Supreme Court, most of the justices' time was not spent in Washington sitting on the Supreme Court. It was out in the country riding the circuit. And let me just say that this was before the interstate highway system. Or Peter Singer's private planes. That was a very deep Alito cut. Right? Justice Samuel Chase in 1800 almost died because he fell through a frozen river while riding circuit. The justices hated it. So why did Congress keep it going? It was deliberate. There's a really important speech on the floor of the House in 1826 by a Pennsylvania congressman who says, "Circuit riding humbles the court. Circuit riding exposes the justices to the people. Circuit riding requires the court to go out and be among the bar. That speech would be a lot more famous if the congressman weren't James Buchanan. Right? It's like, that was a great speech at the time, and then he had to go and be president. So that was something that was also a lever, but most importantly, Congress used to control the court's docket. The court's docket until 1891 was entirely mandatory, meaning the court had to hear a case if it had the power to do so and the party appealed. The justices had no control over the cases that they picked and chose. They fell on them. Right now, Congress gradually relaxes this, and I'll talk about why, to the point where today, almost all of the court's docket is discretionary. So as between the work you have to do and the work you choose to do, which do you enjoy more? In law school, as between the classes we make you take and the classes you choose to take, which ones do you enjoy more? Don't answer that question. Right? This was, again, a way of controlling the court. The court was always looking over its shoulder because if it got too far out of line, Congress would do one of these things. It's a great quote by the Harvard law professor Paul Freund. He said, "Judicial independence means that the court should not be responsive to the weather of the day, but that it must be sensitive to the climate of the era." Right? That an independent court was one that could rule however it wanted to in an individual case. But its broader pattern of behavior was what needed to be accountable to the other branches. That was what we had for the better part of 200 years. Okay, so how do we get there? We have the sort of the early court finding its way. We have the court during Reconstruction asserting more and more power over Congress without pushing Congress too far. We have the famous switch in time in 1937 when Congress holds a gun to the Supreme Court's head, or at least FDR does, and the court doesn't quite blink but doesn't not blink, right? The court walked this tightrope where it preserved its independence by being responsive, by being accountable. All right, and then there's the denouement of this whole story. And the denouement is May 14th, 1969, before Neil Armstrong ever fake walked on the moon. He really walked on, okay. These days, you never know. May 14th, 1969 is the day that Justice Abe Fortas resigned. That date is meaningful for two reasons. The first is it's the last day on which a majority of the Supreme Court was appointed by Democratic presidents. Hasn't been true since. But second, why did Fortas resign? Fortas had gotten into a little bit of trouble because he had a cozy relationship with a shady financier. I've given a version of this talk before where like one of the financier's grandkids was actually in the audience. And I didn't know, and so I used a slightly more pejorative word than shady. I'm just going with shady. But he resigns because Earl Warren walks down the hall to his chambers and says, "Abe, you have to resign for good of the court, because if you don't, Congress will come after us." And Fortas resigns to avoid Congress. Imagine John Roberts walking down the hall today. "Clarence, you have to resign for good of the court or else Congress will come after us." Right. No part of that story is remotely conceivable. But that is, I think, a powerful illustration of how much changed so quickly. So what were the key moments along the way? So the first is, and I think we don't pay nearly enough attention to this, giving the court control over its docket allowed the justices to set their agenda. It's not to say that the court shouldn't have some control over their docket, but by giving the court complete control, right? Congress lost the lever. Congress lost the ability to sort of push back here and there. The court basically gets to choose the cases it hears and do whatever it wants. One example of this, in the October 2024 term, so the last full term, not the current one, the Supreme Court did not take a single direct appeal from a state criminal conviction. Not one. That used to be bread and butter for the Supreme Court, and they've gotten totally out of that business. Instead, what are they taking? They're taking the culture war cases. They're taking the ideologically divided, let's have fun with con law cases, right? That's because of docket control. That is the court not being answerable to anybody about the cases it hears. Congress gradually stopped pulling the other levers. So in 1937, in the middle of the FDR court packing fight, Congress stopped doing the whole one pension at a time and created a permanent retirement system for the justices. under which Congress can no longer leverage their pensions. The pensions are now part of the office, where Congress going after it would be unconstitutional. 1964 is the last time Congress messed with the court's pay. In 2001, in March of 2001, when Justice Kennedy went across the street to testify in support of the Supreme Court's budget, something that the justices used to do all the time, he got raked over the coals by the Democrats on the House Budget Committee, who were pissed as hell about Bush versus Gore, and asked him to defend Bush versus Gore in the middle of a congressional hearing. We haven't seen that in 25 years, right? Congress has sort of gotten out of the business. Part of what also happened is, these developments, all of this hollowing out, did not start 10 years ago. It started decades ago. But for a long time, the court still had a very well-preserved center. It had, whether it was John Marshall Harlan, or Potter Stewart, or Lewis Powell, or Sandra Day O'Connor, or Anthony Kennedy. Those justices weren't great institutionalists. What they were moderating influences. Where whatever the craziest instincts were of the wings of the court were moderated by not wanting to alienate those justices. That starts hollowing out in 2006 when Justice O'Connor retires. You may not remember that Justice O'Connor's, the first nominee to replace Justice O'Connor was John Roberts. The second nominee to replace Justice O'Connor was Harriet Miers. And it was only when the Republicans, the right side, killed the Myers nomination that we got Justice Alito. No more center, No more justices in the middle. Even more aggressively since 2018, when Justice Kennedy retired and was replaced by Justice Kavanaugh. And then if you like symbols, there's also the court's increasing insularity. In 2010, again, back to where I started with the picture, things that are not the most important thing, the court closed its front doors permanently. Those 17 feet tall, 13-ton brass doors in front of the court, closed them ostensibly for security reasons. This led to my favorite opinion by Justice Breyer in his whole career on the Supreme Court. It was a dissent from the closing of the doors. Like architecture critic and symbolism. But let me give you another example. The justices' speeches. If you go to the Supreme Court's website, there is a page for the justices' speeches. I didn't look today, but at least as of yesterday, the last 3 entries were all speeches by Justice Jackson. The previous entry was by Justice Ginsburg. Right. You all understand the math there, right? There have been some speeches by the justices since 2019, and yet none of them are on the court's webpage. This is a court that just does not think it has to explain itself in so many different ways to us. And I think that that's a part of all of these developments. Okay, so that's the court we had and how we got to the court we have. I'm going to close by talking about the court we need. Because this is where I think there's really debate, even among those who are critical of the Supreme Court already. So first, why, in my view, weakening the court, as so many folks understandably want to do, would be myopic. At least in our current political moment, courts, I think, are better situated and have been better situated to protect individual rights, especially minority rights, than the democratically elected branches. One of the principal justifications for a federal judiciary at the Constitutional Convention was to protect against a tyranny of the majority. My whole career, we've talked about the concern of a tyranny of the majority, but it's never happened. Well, and look at what's happened over the last year, Consider the role that federal courts, especially federal district courts, have played over the last 13 and a half months in enforcing legal constraints against the executive branch and standing up for the rule of law. Now, the numbers here are a bit complicated because so many of the headlines are about all of the Supreme Court's interventions. But even if we're going to be generous in counting, the Supreme Court has intervened on behalf of President Trump about 24 times. We are now over 250 adverse coercive rulings by federal district courts against Trump administration policies. I know math, again, hard, but 24, 250. And that's not counting the literally 4,500 immigration detention cases where federal judges of every stripe have ordered the release of individuals who the government is trying to hold without bond. The federal courts have really been, I think, a powerful bulwark over the last 13 and a half months, They've had that power because we have accepted that an independent judiciary can play a critical checking function. To weaken the Supreme Court, I think, is to risk that. Because I don't know how many folks out there would say, I want a weaker Supreme Court, but a stronger district court in Massachusetts. Well, okay, I know people from Massachusetts who would say that. But that's the problem. How do you distinguish between weakening one court and weakening the courts? The lawyers might say, well, here's my 80-page law review article on how to do it. But when you're trying to actually speak to the public, it's not going to work. So why is strengthening the court actually urgent? So the court cannot enforce its own mandates. I alluded to this already. This is literally in the Supreme Court's rules. You probably did not think when you came here tonight that you were going to learn about Rule 45.1 of the rules of the Supreme Court of the United States. But look at what it says. All process of this court, meaning all of our formal paper, issues in the name of the President of the United States. That's not new. That is the third rule the Supreme Court adopted back in 1790. I think the first rule was its seal, right? What this means is that the court depends upon the executive, who is him or herself, one day, politically accountable and democratically accountable. So what prevents parties historically from defying the court? How do you ensure that there's not defiance? So popular support, and when that fails, the Army. This is a picture of the 101st Airborne desegregating Little Rock Central High School in 1957. There is, for those of you who are football fans, there's another version of this picture where just off to the right is a young Jerry Jones, the owner of the Dallas Cowboys. He's not on the good side. Just you know. It's awkward. But why did Eisenhower send the Army into Little Rock? Eisenhower, he was not anti-civil rights, but I don't think anyone would say he was in a hurry to use military force against his own citizens to vindicate, at the time, a deeply divisive Supreme Court mandate. He thought it was his job. He thought it was his responsibility. He thought that the political consequences of not doing so would be cataclysmic. Ditto back to Nixon in 1974. Why does Nixon turn over the Watergate tapes, the very tapes that actually hastened his downfall? It's because he had become persuaded that if he defied the Supreme Court's ruling, he would lose what Republican support he had left in the Senate. He thought he was going to survive, not that he wasn't going to be impeached by the House, but that he wouldn't be convicted by the Senate. Because it would never be conceivable that a president's own party in the Senate wouldn't vote to convict him after the House voted impeachment. That's what happened with Trump twice. But hey, so Nixon complies because he knew his career would be over if he didn't. Just turned out the smoking gun tape had the same effect. Do we trust this guy to comply with an adverse Supreme Court ruling? Right. So this is a truth. Is that what, a post on Truth Social? Calling it a truth is like so Orwellian. I love it. This is an attack that President Trump launched against Chief Judge Jeb Boasberg, the D.C. District Court Chief Judge, last March. Why was he so mad at Chief Judge Boasberg? Because Boasberg had ordered the government to stop sending alleged Venezuelan gang members to El Salvador under the Alien Enemies Act. And this is the president directly attacking him by name, calling for his impeachment, impugning his credibility. But the president's not alone. The attorney general filed a misconduct complaint against Chief Judge Boasberg. That's never happened before. It was summarily dismissed by Chief Judge Sutton in the Sixth Circuit, which was good. But the Deputy Attorney General, Todd Blanche, at the Federal Society National Convention last November, kept referring to the war that the Department of Justice is engaged in against federal district courts. Stephen Miller, the Deputy White House Chief of Staff, keeps referring to any ruling by a judge blocking a Trump administration policy as part of the legal insurrection against the administration. So these attacks have stepped up. These are efforts to undermine the courts. This is why you actually, I think, and we all do, need stronger courts. So what if it is the president who defies an adverse ruling? I like this picture. I don't know what John Roberts is thinking at this moment. But what do we do about that, right? That's why we need a court with broad credibility, the likes of which the current court has lost. It is a court that is popular, that can stand up to a popular president, right? It is a court that has credibility, that can use that credibility when necessary to protect the very kinds of minority rights, the very kinds of dissent that Senator Chavez so elegantly and eloquently fought for. And so I mentioned the attacks. We need a court that's more accountable because more of the more that the American people have faith that the justices aren't just voting on their political preferences or the wishes of their financial backers, the more we might be willing to accept decisions we disagree with, as opposed to saying, well, this is why we have to kneecap the court. And we need such a court so that if we ever get to a moment in which a president is thinking about defying the court, the cross-spectrum consequences would be so cataclysmic that he's impelled to comply. That moment, I think, might be coming sooner rather than later, right? I mean, this used to be a fun academic exercise. It's now neither fun nor academic, nor an exercise. The Holy Roman Empire, neither holy nor Roman, nor an empire. Discuss. All right, so how do we do that? I mean, I've been sort of hitting you with all of this like, oh, it's all bad. Typical Mets fan. But I want to sort of end on a couple of notes of optimism, because I actually think this is not as hard as it sounds. The first thing we have to do, and this is something that this is a message I give to my law professor colleagues, to my students, to anyone who will listen, we have to change how we talk about the court and how we think about the court. We are so conditioned, whether we're lawyers or not, to basically view the Supreme Court as the sum of its rulings, as the sum of the decisions, many of which we may not like, which means we fall right into that vicious trap of viewing the court entirely as an ideologically divided institution, as opposed to an institution that has totally run off the rails, right? When you are a hammer, everything is a nail. And so when we view the court only through the lens of its merits rulings, we think of the court only in those terms. The more we talk about the court as an institution, in conversation or not with other institutions, the more we're not actually picking a fight with those who are more sympathetic to these rulings. The more we're saying, hey, whether you think this decision is right or wrong, shouldn't the court explain itself? That shouldn't be controversial, and yet sometimes it is. This is why, to me, the real point is that conversations about Supreme Court reforms, about how to fix the court, about what to do to the court, should be about restoring accountability, not punishing the Republican appointees, not one-upping the one-upsmanship when it comes to expanding the court, but about making the court more accountable in general. Some of this is super nerdy and small, just like docket reform, Congress bringing back some categories of cases that the Supreme Court has to hear, not because those cases are important, but because they're not, right? Have the justices spend more of their time doing boring law stuff, as opposed to, we are high sages who have broad constitutional interpretive powers. That's docket reform. For all of the ethics conversation, what about an Article III Inspector General? Right, an officer within the judicial branch who could actually provide, I like the applause for this, hey, this is the right audience. It's funny, because usually I say Inspector General, I get quizzical looks, like, why? An Inspector General who, right, as opposed to leaving it to ProPublica to document the extent to which the justices are or are not complying with the relevant financial disclosure rules, are or are not paying their taxes correctly, are or are not recusing in the right cases, what if there was an ombudsperson whose job was to actually provide annual reports? I think two things would happen. One, the justices would be incentivized to behave better, and two, when they didn't, that would actually be a less controversial report, one that maybe the House of Representatives could use as a basis for impeachment proceedings if we ever got that far. More than that, right, an Article III Inspector General could also clean up some of the mess in the lower federal courts where there's not nearly enough accountability for workplace sexual harassment and other similar problems. So again, that's not about Republicans versus Democrats. That's not about liberalism versus conservatism. That is about a healthier institution that is more accountable to itself and to us. And this is, I think, the most important point to leave you with, right? Institutional reform pressure has already moved the needle. So at some point, someone's going to ask me tonight, you really expect Congress to do anything? And the answer is no. not this Congress. But two things are true. The first is the court has already shown itself susceptible to public pressure. Let me give you two examples. The first is on the shadow docket, right, with these emergency applications. This Monday night, 2 days ago, right, today's Wednesday, Monday night, the court granted an emergency application in a case out of California about a California law that barred public school teachers from outing their transgender students to the students' parents. And the court wrote an opinion, and Justice Barrett wrote a concurrence. Part one of her concurrence was, surprise, substantive due process is not dead, which, after Dobbs, is kind of weird. But part two of her concurrence was, by the way, look at us, we wrote an opinion. I don't know who she was responding to. Okay, I do know who she was responding to. But, this is Justice Barrett literally saying out loud, we heard all the criticism about not writing. Look, we wrote. Not only did we write, but I wrote separately to make sure you noticed that we wrote. That is a responsive court. The ethics stuff. So in November 2022, the court issued this, I'm going to put it in scare quotes, code of conduct, which to call it a half measure, I think is to do grave injustice to all half measures everywhere. But that's not the story. The story is that the court did anything. Within a court that, the unofficial mascot of which is a turtle, a court that measures time with a sundial, within 7 months of the first newspaper stories and ProPublica stories, felt impelled to at least look like it was doing something. I think we lose in our sort of frustration with the substance, the significance of the symbolism, which is that the court felt like it had to act. Why? Because of us, right? Because of public outrage and because of public frustration. This is evidence that when we talk about the court, not in the terms of Dobbs was wrong, but in the terms of no responsible institution behaves this way, we make progress, right? And we can actually affect change even without Congress. And this comes back to Senator Chavez. A nation of dissenters needs courts to protect dissent, because the real danger of weakening the courts beyond the point of no return is that there will be no one left to protect the right of dissent that Senator Chavez argued for and exemplified throughout his career. And so that's why it's such an honor for me to be giving the Senator Chavez lecture this evening. It's an honor for me to be here. It's why I write my nerdy little newsletter about the Supreme Court. And it's a real honor for me to be here, and I look forward to your questions. Thank you very much.
Wow, wasn't that absolutely terrific? So at this point, we will open the floor for some questions. If you'd like to ask a question, please state your name before asking the question, and we've got a couple of mics that will circulate around.
Camille, right in the middle aisle. There's a microphone coming. I promise, no more math jokes.
I have a question about whether or not this court can withstand the degradation, of the Department of Justice for another 3 years.
Yeah. Whew, that's a big question. So it is really quite, the behavior of the Department of Justice is a talk unto itself. I think, what's interesting to me is perhaps the one office in that entire department that still looks somewhat familiar compared to prior administrations is the Office of the Solicitor General, is the office that represents the United States in the Supreme Court. I think we call them the SG. The SG has pushed the envelope in some of these cases. Some of the briefs have made arguments I would never have thought the Justice Department would have made before. But what's really striking to me is that I think there are already signs that the court is starting to give the SG less deference and less credibility and less respect than it would have historically. Historically, that office had a lot of sway over the court in telling the justices which cases to take, in how to structure the arguments, in participating in the arguments. We have seen a couple of times in the last couple of months, the SG's office urged the court to grant emergency relief, and the court said no. Right, not when it was Trump, when it was another. So in the California redistricting case, for example, when California Republicans asked the Supreme Court to step in and block California's, Texas revenge map, right? The SG filed this extraordinary friend of the court amicus brief saying, yes, Supreme Court, you should totally do this. And the Supreme Court denied that application with no writing and no dissents. You don't see that when the SG throws its weight around every day. So, I think the court is already showing signs that it's going to rely upon that office less. The messier piece of this is there are other cases where the Department of Justice has been, at least in part, responsible for defiance of lower federal courts, and the Supreme Court hasn't pushed back. I guess all I would say about that is those were earlier last year before this much broader pattern of bad behavior, I think, had surfaced. I think there will be less of that going forward. I think the court is going to be less tolerant of the SG. I think the court is going to be less deferential. And just one other data point for this. In December, right before the holidays, for as much as the court has been acquiescing on emergency applications from the Trump administration, it denied one really important one in the Illinois National Guard case. And the SG had put a lot of work and a lot of effort into trying to get the court to take that case. So I'm with you that there are problems. I think the court is starting to implicitly, they'll never say it out loud, act in response to the perception that that office is not entitled to the respect it used to be.
My name is Ethan Watson, and I'm a huge fan of your Substack. It's a little off topic, but I was curious if you could talk about your writing process a little bit and what goes into that because it's just like candy. I mean, I read it and I really enjoy it, and it's not a topic I was very interested in before, and so I was curious if you could talk about that.
Oh my gosh, can you tell my daughters that? So my daughters complain all the time about my writing. What is my writing process? My writing process is Supreme Court does something bad, I am angry, I open my laptop. So Monday night, I was on a plane Monday night, shortly after the 2 emergency application rulings came down. And Monday night's post might have been a little more stream of consciousness than usual. I started the newsletter 3.5 years ago. I mean, let me be fair. My wife started the newsletter 3.5 years ago. She is the brains behind the operation. Because that was the first time that Twitter started dying, its many steps of death. But 2, I really thought that there was a missing resource out there, that there's all this really good frontline journalism about the court, but nothing that's sort of taking the time to put stuff into context. And it seemed to me that a nerdy newsletter that people could choose to read if they wanted to was a way to put the headlines into broader context. So when the Supreme Court does something that looks bad, is it really bad? I really think that all of us who do law, I mean not just law professors, all of us who practice law, I think more than ever have an obligation to help educate the people around us. Whether they're lawyers, law students, or just members of the public, so that everyone's better situated to understand what is normal and what is not normal and act accordingly. And so to me, the newsletter is that. It's my chance to basically both, 1, cope, I write to cope, but 2, try to give more people more of a window into what is, as I think we talked about, such a cloistered institution historically. And so if it's doing that for you, I'm grateful.
My name is Jeff Vescovi, and I had a quick question about jurisdiction stripping. I was wondering how jurisdiction stripping could fit into a potential proposal for reform of the court.
Sure. I mean, so jurisdiction stripping, which, again, for the non-lawyers, this is Congress using its power over the court's appellate jurisdiction to say, hey, Supreme Court, you can't hear any more Second Amendment cases, or you can't hear this particular climate change case. The problem with jurisdiction stripping is that there's no clear consensus that Congress can do it ad infinitum, that Congress can do it to the maximum extent. And indeed, even I, who don't like the Supreme Court very much, think that there are limits on how far Congress can go to strip the Supreme Court of jurisdiction, because imagine the following statute. Imagine a statute that says on all Second Amendment questions, every case in federal court shall be transferred to the Fifth Circuit, and there shall be no appeals. Then the Fifth Circuit is the Supreme Court. And Article 3 says there shall be one Supreme Court, not two. So, I think Congress has a lot of room to use its control over the court's jurisdiction as a lever for the reasons we've been talking about. The problem is that when Congress uses that to go as far as we would want to go to really kneecap the court, it raises what to me are legitimate and serious constitutional questions. And I think we'd be much better off if Congress were to use the same energy and momentum toward ends that are clearly constitutional, but that might produce the same effects.
Thank you. Hi, my name's Melissa Anderson. I'm a 2L. I was just wondering how we as law students and we as members of this community can take understanding into action.
Yeah. Gosh, that's a good question. So I guess I have a couple of different answers, right? So the first is, when I was in law school, I had no friends, but I assume you have some friends. My daughters would say that wasn't limited to law school for me. I find that there are so many folks out there who want to know more about this stuff, who look to people who know more to educate them. And so I think it starts at home, whether it's your family or your friends, like the Supreme Court is affecting all of our lives. When it does, you are uniquely situated, even as a 2L, to help people understand the Supreme Court in a way that they can't. And so I think it starts just with your verbal advocacy to your community and to your people. The second piece of this, and this is something I tell my students, because teaching at Georgetown, we are in it. We are inside the Beltway in every sense of the not good sense of the term. I also think it's really, really important for law students in particular these days to not confuse cynicism with nihilism. It is so easy to look at the headlines and to be weighed down by the latest atrocity, the latest lawlessness, the latest violation, and miss all of the ways in which what is actually checking the government is law. Maybe not as much as we want it to, maybe not in the ways we want it to, maybe not even to the degree we want it to, but it's law. Who's responsible for that? The lawyers. And so it seems to me that now is the time, especially for young lawyers, for people thinking about going to law school, people who recently this is actually, I think, a critical time to be active as a lawyer, no matter what you're doing, whatever you are doing to fight. The ABA Model Rules of Professional Responsibility in the preamble talk about how lawyers have duties not just to their clients, but to the legal system. And one of those duties is standing up for the rule of law. And I think one of the ways you do that is by being realistic about what's happening, but not doomers. Too many doomers. I have so much evidence for you of law working. The Birthright Citizenship Executive Order never went into effect because of law, right? Because of courts, because of lawyers, right? Other than the one, first burp of people who were sent to El Salvador, the Alien Enemies Act has not been used to remove anybody from the United States since last March. That is law and lawyers. And so how do you take words and turn them into action? Whatever your contribution is going to be, wherever you are working the summer after your 2L year. If you're on law review, what are you publishing in the law review? If you are in a clinic, what cases are you working on? They all matter. I was about to say even the little cases. The little cases today are huge. I mentioned the immigration detention cases. The reason why there have been more than 4,500 immigration detention cases is because of a stupid 1996 statute that says you can't have class-wide relief in those cases. That means you need more lawyers. And so part of it is using your voice to educate. Part of it is using your skills to actually fight for whatever you want to fight for. And part of it is just, don't let the bastards get you down. Right? Law is not perfect. And law is not an end unto itself, but law is, I think, doing a heck of a lot more right now to keep all of us not safe, but at least safer than almost anything else. And I think, figuring out that everyone's going to operationalize that differently, but it starts with acknowledging it.
On? Yes. First, please forgive my raspy, allergy-laden voice here. Thank you for having the courage to share this information. In this environment, so many of us need a voice like yours. I appreciate you, number one. I'm asking what I thought my colleague was going to ask here. When you spoke of the idea of creating an inspector general for the courts, I love that idea. One, who would enforce? Two, how do we ensure that a presidency cannot fire them all?
Yep. Those questions are very related. So let me start with the second question, because that has an easier answer. The way that the Constitution divides power, in Article 3 Inspector General would be a judicial officer, not an executive officer. And so that would mean that he or she would be appointed not by the president, but by the Supreme Court, by the full court, not by the Chief Justice, because the Appointments Clause says courts, not justices. And you might say, well, this court would never appoint someone responsible. I actually don't think that's. I think this court would pick, someone who actually would do not the job I would do, but maybe we don't want me as the Inspector General. That might be a little bit too wild. So the first part is the president would have no control, right, over the Inspector General, and if he tried, he'd lose. Right? There's a case right now in which the president has tried to fire the Register of Copyrights. So for the IP lawyers in the audience, on the theory that, are you all sitting down? The argument is that the Library of Congress, I'm going to say that one more time, the Library of Congress is an executive branch agency for purposes of the Federal Vacancies Reform Act. They're going to lose that case. They've already lost that case. Anyway, so the second question, ma'am, doesn't bother me that much, because I think that's the president will be safe from that. The enforcement piece, that is the problem. I mean, I am loath to disagree with Justice Kagan, but I think she's wrong about the notion that they could appoint a panel of lower court judges or state Supreme Court justices. I mean, if you guys, it would be fine. To enforce an ethics code, because then whoever's enforcing the code is the Supreme Court, not the Supreme Court. The way that you enforce an ethics code against the justices is you name and shame them. The name and shame, which will hopefully incentivize better behavior, and when it doesn't, which will create public reports that then actually really could substantiate impeachment resolutions in the House. The problem is that when we're just litigating this in the court of public opinion, I know you guys will be shocked to hear, but there are people who don't trust certain media sources, right? And so enforcement is a huge problem. This doesn't fix it, but it gets as close, I think, as we can to fixing it without violating the Constitution. It's not a perfect solution. I just think it's the least worst alternative.
Thank you so much, Professor. We are just so honored to have you. This is probably a flippant question, and maybe it's kind of partisan too, but I mean, is it wrong for us to be happy? Like let's say I'm a professor of bankruptcy. Is it wrong for me to be happy when they don't take the cases because they're doing so much harm to the little guy and also don't really know what they're doing?
It's funny, the last time I got that question was from a patent lawyer. So it is not wrong, I think, to say that as a specialist in X field, I'd rather the court not mess up my field than mess up my field. But, I mean, one of the big cases from that term a couple of years ago when it was like all big cases was the Purdue Pharma bankruptcy case. And without defending the court's decision, I will just point out that it did not split the court ideologically. And so when folks talked about it was a hugely impactful ruling. It was a very big deal. It got no public attention as being about the ideologically riven court because there were weird coalitions on both sides. And those cases used to be much more common. The term that the Supreme Court press corps used for them was strange bedfellows, which I always thought was a little awkward. But we don't have strange bedfellows anymore. So one crazy statistic on emergency applications, since Justice Jackson joined the court, which is now almost 4 years ago, in every emergency application from which at least one justice has publicly dissented, so where there was at least some division in the court. There has yet to be one where a Democratic appointee dissented, and so did one of Thomas Alito or Gorsuch. Right? It's always one side of the court dissenting or the other. And so, yes, the court will mess up the less ideologically charged, coded cases too. I just think that that is actually much healthier for the court as an institution to be messing those up also, even if it's bad for the bankruptcy lawyers.
On Siegel, and I really love listening to you on Amicus. But my question is, in this era when so many of these really, really important matters are being decided on the shadow docket without any explanation of the ruling, and in a lot of the merits cases, the decision is based on the justices' historical research on their own and made without any regard to an extensive trial court record. My question is, how on earth do you teach and do you examine students for appellate practice or for constitutional law?
Do you want to come do it? So this actually, I think, goes back to my answer to your question as well. I teach a couple of classes. I teach the 1L civil procedure class, which is not insulated from these pressures, but is at least not completely beholden to them. Motions to dismiss are still motions to dismiss. Summary judgment is still summary judgment. It's actually a wonderful opportunity to show students that there's still law. But then there's the upper level federal courts class. And the upper level federal courts class historically is about the question, why do we have federal courts? And there are different answers to that question, but those answers are powerful and they reflect different values about the federal judiciary. This court has made it harder. And so what I try to do in my classes, and every professor does this differently, is I try to tell my students three things at once. Here is what the court says the rules are, right? Here is how we got there historically, and here's where there's room to doubt that the court will take those rules seriously in every case. And it seems like it's that kind of three-dimensional education that situates them the best to go out into the world. Because there are still plenty of courts out there that follow the rules, whether because they have to or because they want to. The rules still matter in the overwhelming majority of cases. If you get into a property dispute with your neighbor or a contract dispute with an employer and employer, the Supreme Court's Michigas is not going to mess with that. That's still law, right? But it does seem to me that it's important to understand where the other side is. So there's a German writer from the World War II era named Ernst Fraenkel who wrote a book about the dual state. He talked about the normative state. This was the state that where everything was happening normally. And the rules were being followed, and that was everything that was great. And then there was the prerogative state, which is where the government was acting in the exception. And I think now is a time where we have to teach both. And teach everybody about why the normative state is really important, but also how sometimes it empowers the prerogative state too. And that's what I try to do in my upper level classes. The 1Ls aren't ready for that.
I think we actually need to wrap up. Can you please join me in thanking the Tristani and Chavez family for this wonderful opportunity, and a final thanks to Professor Vladeck. And as a token of our thanks, we'd like to offer this Nambe Bowl to Professor Vladeck. Thank you so much. Thank you, everyone, for being here and being such the important part of the heart of the law school and the community that we are. Thank you.
It's gorgeous. Thank you.
It's a New Mexico
Yeah. Oh, no, yeah. And it's a hard one.
It is a hard